Nevada Construction Business and Law Manual, Chapter 3, Labor Management. Overview. Federal law requires that employee personnel files be kept up to date and contain all important information related to regulatory provisions. Under federal law, accurate payroll and deduction information is mandatory, and large fines could be assessed for failure to properly file or pay withholdings, income tax, Social Security, and unemployment tax as required. Federal requirements concerning overtime pay, minimum wage, and child and youth labor standards can be found under the Fair Labor Standards Act, FLSA. The law also establishes and describes requirements for keeping such records as employee information, pay rates, record keeping, and deduction from wages. The Wage and Hour Division of the United States Department of Labor is the enforcement agency for the FLSA. A business owner must also be aware of many of the other laws that relate to employer-employee relations. Among these are federal income tax, Social Security and Medicare withholding, federal unemployment insurance, child and youth labor laws, Americans with Disabilities Act, Immigration Reform and Control Act, workers' compensation, child support payment regulations, and federal privacy acts. Records for federal employment taxes must be kept for a minimum of 4 years and be available for IRS review. These records include Employer Identification Number, EIN, amounts and dates of all wages, fair market value, and in-kind wages paid, names, addresses, Social Security numbers, and occupations of employees and recipients, any employee copies of forms W-2 and W-2C that were returned as undeliverable, dates of employment, periods for which employees and recipients were paid while absent for sickness or injury, amount and weekly rate of payments made to ill or injured employees by the company or third-party payers, copies of employees and recipients' income tax withholding allowance certificates, W-4, W-4P, W-4S, and W-4V, dates and amounts of tax deposits made and acknowledgement numbers for deposits made by using the Electronic Federal Tax Payment System, EFTPS. Copies of returns filed, including 941 telefile tax records and confirmation numbers, records of fringe benefits provided, including proof of such benefits. In addition to records that must be kept in employee files or compliance with both federal and state regulations, the employer must also have a system for documenting and easy access to most recent personnel information available concerning the employees. Important personal data, address, home, phone, dependents, etc. File hiring information, job application, work experience, references, medical information, and wage salary requirements, W-4 withholding statement, I-9 immigration form, and other necessary state and federal forms. An employer must verify that new employees are legally eligible to work in the United States. This includes having them fill out the U.S. Citizenship and Immigration Services USCIS form I-9 employment eligibility verification. These forms can be obtained from an USCIS office or by calling 800-375-5283 or from the USCIS website at http://uscis.gov. Refer to the section entitled Immigration Reform and Control Act later in this chapter to obtain more information concerning USCIS regulation. That's the child support payment regulations. Congress established a child support enforcement program in 1975 under Title 5D of the Social Security Act to collect child support. The program's goal is to ensure that both parents support all children financially and to reduce the number of children receiving public assistance. The Child Support Program is a joint effort involving federal, state, and local agencies administered in the particular state. Federal regulations require that the state maintain records necessary for the proper operation of the 5D program, including records concerning the distribution of support collections. Chapter 11, Labor Laws, covers the laws that require employers to report all new hires to state agencies for the transmittal of new hire information to the National Directory of New Hires. This increase of government's ability to track delinquent parents across state lines. The law also expands and streamlines procedures for direct withholding of child support from wages. Employee versus independent contractor. An employer must generally withhold income taxes, withhold and pay Social Security and Medicare taxes, and pay unemployment tax on wages paid to employees. An employer does not generally have to withhold or pay any taxes on payments to independent contractors. Since a company's overall costs are typically less for independents than for employees, some companies might try to get away with not paying taxes for their own personnel by claiming that these workers are independent contractors. Some owners may be honestly unaware of the distinctions between the two. Whatever the reason, an employer who does not withhold employee taxes or pay required payments, Social Security, Medicare to the government when they are due could be severely penalized as a result. Therefore, it is extremely important for all concerned, the workers, the employer, and the IRS, that workers' status be clearly defined. Helpful information can be found in the IRS publication 15-A, Employers Supplemental Tax Guide 2017 at http://www.irs.gov/. IRS uses a number of common law factors as guidelines when deciding if sufficient control on the part of the employer is present to establish an employer-employee relationship. Under the common law test, an employer-employee relationship is present when the person for whom services are performed has the right to control and direct the individual who performs the services as to both the results to be accomplished by the work and details and methods used in achieving the end result. Figure 3.1 lists some of the factors considered in guidelines and compares typical characteristics of both an employee and an independent contractor. Figure 3-1, employee versus independent contractor. Employee must follow set or mandatory instructions where, when, how to perform work, receives and or is required to receive training, provides essential services which meld into overall business operation, required to render services personally, does not supervise or hire others, required to work set hours, required to perform tasks in set manner, routine schedule, paid at regular intervals, expenses are paid or reimbursed, tools and materials are furnished, does not invest in facilities and or equipment used to perform work, compensated for services at fixed rate regardless of profitability, performs services for only one firm at a time and non-project basis, and on a non-project basis, may end the relationship at any time. Independent contractor follows own individual instructions, performs work based upon independently established procedures or industry specs, skilled professional requiring no company training to adequately perform services. Work performed is a unique service, not an integral part, has assistance or employs while retaining the right to hire others to perform the required work, pays to hire assistants to perform all or part of the project, retains the right to complete work at any time or according to contract requirements, has full choice over routine or manner in which to perform services to meet contract requirements, payment by project or based on a fixed fee, no reimbursement for out-of-pocket expenses, furnishes own tools and materials, possesses and invests in facilities and equipment to perform services, shoulders the possibility of incurring a loss and realizing a profit, has numerous clients at one time and is not financially dependent on any one, may end a relationship upon completion of a contract or breach by the other party. The following scenario is one example of how the provisions of the employee-employer guideline have been interpreted by the IRS. Question. A salesman for my company worked full-time on commission. Although this person provided the company with a completed W-4 form, Employee Withholding Allowance Certificate, the company sent in Form 1099, Independent Contractor, and did not withhold any taxes. Is the salesman liable for the taxes? Answer. If the salesman is an employee and the company treated him as an independent contractor, then the company is responsible for the taxes. This type of situation occurs frequently because the proper classification of workers can be confusing. Unfortunately, some employers purposely misclarify the workers to save on taxes. If there is any doubt about how an individual should be classified, either employee or independent contractor, then the employer should submit Form SS-8 to the IRS determination of worker status for purposes of federal employment taxes and income tax withholding, revised 2014, to verify the status of the worker. IRS forms are available on its website at https://www.irs.gov/forms-instructions-state-specific exceptions. While the information provided above is valid in most cases, contractors should examine the state requirements to see if there are exceptions to those definitions. For example, in the state of Nevada, a subcontractor working for a contractor must be licensed. Payroll taxes, reports, due dates, and payments. Employers are responsible for withholding taxes from employees' paychecks and sending them to the proper governmental agencies. Among these are income, Social Security, and Medicare withholdings. Although there are software packages that may assist the contractor in tracking due dates and calculating the amount of taxes due, the contractor needs to have basic understanding of the tax laws and regulations. The Federal Unemployment Tax Act, FUTA, together with state unemployment systems, provides for payments of unemployment compensation to workers who have lost their jobs. Most employers pay both a federal and a state unemployment tax. Only the employer pays FUTA tax. It is not deducted from the employee's wage. State unemployment taxes are also paid by the employer and are not deducted from the employee's wages. Each state has a different rate and different wage limits from which the taxes are calculated. Federal government requires that employers complete standardized governmental forms for recording employee information and the payment of taxes. Some of the more important taxes and their required forms are explained in the following section. Important forms. The following two forms are filled out the day of employment. Form W-4. Each employee must fill out IRS Form W-4, Employees Withholding Allowance Certificate. The employer uses the filing status and withholding allowances shown on this form to figure the amount of income tax to withhold from the employee's wages. If a new employee does not provide a completed Form W-4, the employee should withhold tax as if this employee is a single with no withholding allowances. A Form W-4 remains in effect until the employee provides a new one to the employer. An employer who receives a new Form W-4 should not adjust withholding for pay periods before the effective date of the new form. Also, an employer should not accept any withholding or estimated tax payment from employees in addition to withholding based on their Form W-4. If they require additional withholding, they should submit a new Form W-4 and, if necessary, pay estimated tax by filing Form 1040-ES, Estimated Tax for Individuals. Form I-9, the Immigration Reform and Control Act, IRCA, requires the employer to verify that each new employee is legally eligible to work in the United States. Both the employer and the employee must complete the U.S. Citizenship and Immigration USCIS Form I-9, Employment Eligibility Verification. Additional information concerning eligibility can be found in the section entitled Immigration Reform and Control Act, IRCA, in this chapter. Additional forms. W-2. The employer must file IRS Form W-2 wage and tax statement to report payment to employees such as wages, tips, and other compensation, withheld income, Social Security, Medicare taxes, and advanced earned income (EIC) payments. The employee's correct name and Social Security number (SSN) must be entered on this form. The employee is required to show Social Security card to the employer. Employers who do not provide the correct names and Social Security numbers of their employees on the Form W-2 may incur a penalty. Caution: do not accept individual taxpayer identification numbers, ITINs, in place of a Social Security number for employee identification or for work. An ITIN is only available to resident and non-resident aliens who are not eligible for employment in the United States and need identification for other tax purposes. An individual with an ITIN who later becomes eligible to work in the United States must obtain a Social Security number. Form 1099-MISC. Form 1099-MISC miscellaneous income must be filed for individuals who have worked for your company as independent contractors and have earned $600 or more during the year. Form 8300, the employer must file IRS Form 8300, report of cash payments over $10,000 received in a trade or business. If more than $10,000 in cash is received in one transaction, Employer Identification Number, EIN. An employer who is required to report employment taxes or give tax statements to employees or annuitants must have an Employer Identification Number, EIN. The EIN is a 9-digit number issued by the IRS. In order to obtain an EIN, an employer must fill out Form SS4, Application for Employer Identification Number, revised January 2009. If the business was already established, the new employer cannot use the previous owner's EIN. The form has directions for applying by mail or by phone. Wages and employment taxes. A business must withhold federal income taxes from an employee's wage for each wage payment according to the employee's W-4 and the correct withholding rate. Wages that are subject to federal employment taxes include all pay given to an employee for services performed. Supplemental wages are compensation paid in addition to the employee's regular wages. They include, but are not limited to, bonuses, commissions, overtime pay, payments for accumulated sick leave, severance pay, awards. Prizes, back pay, retroactive pay, increases for current employees, and vacation allowance. Vacation pay is subject to withholding as if it were a regular wage payment. Supplemental wages also include taxable fringe benefits and expense allowances paid under a non-accountable plan. How withholdings on supplemental wages is handled depends on whether they are identified as payments separate from regular wages. For further details about withholding for supplemental payments, refer to IRS Publication Circular E Employer's Tax Guide. To figure the amount of federal income tax to withhold from each wage payment, the employer will need to refer to the employee's W-4 form and the methods described in the IRS Publication 15 Circular E Employer's Tax Guide, where tax responsibilities for employers are explained in full detail. This publication can be found on the internet at the following website address: https://www.irs.gov/forms-instructions. Sending certain forms W-4 to the IRS. Generally, the employer must send copies of certain forms W-4 received during the quarter from employees who are still employed at the end of this quarter. Send copies when employees claim more than 10 withholding allowances or be exemption from withholding, and when their wages should normally be more than $200 per week. These forms should be sent to the IRS office, where the Form 941 employer's quarterly federal tax return is filed. The IRS does not require that any other Forms W-4 be absent unless the IRS requests them in writing. Exemption from income tax withholding. An employee who had no income tax liability in the past year and expects none in the present year may claim exemption and income tax withholding. However, the employee's wages are still subject to Social Security and Medicare taxes. A Form W-4 claiming exemption from withholding is valid for only 1 calendar year. To continue the exemption for the next year, the employee must file a new W-4 form by February 15th of that year. If the employee does not give the employer a new W-4 form, the employer must withhold tax as if the employee were single with zero withholding allowances. Withholding on non-resident aliens. In general, an employer who pays wages to a non-resident alien must withhold income tax, Social Security, and Medicare taxes. For exemptions to this rule, consult Publication 515, Withholding of Tax on Non-Resident Aliens and Foreign Entities, revised March 2008. Social Security and Medicare withholding generally, employee wages are subject to Social Security and Medicare taxes, regardless of the ages of the employees or whether they are receiving Social Security benefits. Payroll taxes fund the Social Security program and the Medicare health insurance program. Employees and their employers pay these taxes in equal portions. Employees and their families become eligible to collect these benefits after workers have been employed for a certain time period. Employers must withhold Social Security and Medicare taxes from employees' wages and pay a matching amount to the federal government. Currently, for the year 2009, the Social Security tax rate for the employer is 6.2%. The employee tax rate for the Social Security is also 6.2%, making a total deposited amount of 12.4%. The wage-based limit is $106,800. The Medicare tax rate for the employer is 1.45%. The employee tax rate is also 1.45%, for a total deposited amount of 2.9%. There is no wage-based limit for Medicare tax. All covered wages are subject to Medicare tax. Social Security and Medicare taxes pay for benefits that the workers and their families receive under the Federal Insurance Contributions Act, FICA. Social Security tax pays for benefits under the Old Age Survivors and Disability Insurance part of FICA. Medicare tax pays for benefits under the hospital insurance part. An employer is required to withhold part of these taxes from every employee's wages, and the employer must pay a matching amount. Most employers use IRS Form 941, Employer's Quarterly Federal Tax Return, to report these taxes owed to the IRS. Certain types of wages and compensation are not subject to Social Security taxes. See Circular E Employer's Tax Guide, Section 5 and 15 for details. Federal Unemployment Tax, FUTA. The Federal Unemployment Tax Act, FUTA, with state systems provides for payments of unemployment compensation to workers who have lost their jobs. Most employers pay both a federal and state unemployment tax. The employer reports and pays FUTA tax separately from Social Security and Medicare taxes and withheld income tax. The employer pays FUTA tax from the business funds only. Employees do not pay this tax nor have it withheld from their pay. Employers who have deposited all the FUTA tax when due have an additional 10 days to file after the due date. An employer is subject to the FUTA tax on wages paid to employees during the calendar year if the following two requirements are met. The employer paid wages of $1,500 or more in any calendar quarter for the past or present year. 2. And the employees worked for the company at least some part of the day in any 20 or more different weeks in the past or present year. Computing FUTA tax. For the present year, the FUTA tax rate is 6.2%. This tax applies to the first $7,000 paid to each employee as wages during the year. The $7,000 is federal wage base is federal wage base. The state wage base may be different. Generally, the employer can take a credit against the FUTA tax for amounts paid into the state's unemployment fund. This credit cannot be more than 5.4% of taxable wages. For an employer who is entitled to the maximum 5.4 credit, the FUTA tax rate after the credit is 0.8%. Successor employer. If an owner has acquired a business from someone who is liable for FUTA tax, the new owner may be able to count the wages that the previous owner paid to the employees who remains with the company when the $7,000 FUTA wage base is figured. Determining FUTA tax liability for deposit purposes, FUTA tax should be figured quarterly. To determine FUTA tax liability, multiply the amount of wages paid during the quarter by 0.8%. Stop depositing FUTA tax on an employee's wage when $7,000 for the calendar year is reached. If any part of the wage subject to FUTA is exempt from state unemployment tax, the employer may have to deposit more than the amount of tax previously calculated using the 0.8% tax rate. If a company's FUTA tax liability for the quarter is $100 or less, then the tax does not have to be deposited. Instead, it can be carried forward and added to the liability figured for the next quarter. If the company's FUTA tax liability is over $500 in any calendar quarter, including any tax carried over from a previous quarter, the tax must be deposited by electronic funds transfer, EDTPS, or in an authorized financial institution using Form 8109 Federal Tax Deposit Coupon. Due dates for depositing FUTA tax. Deposits must be made no later than the last day of the month that immediately follows the end of a quarter. The employer reports federal unemployment tax on IRS Form 940. Employer's annual federal unemployment tax return. Some businesses qualify to use the simpler Form 940-EZ instead. For a fourth quarter payment with liability of over $500, the entire amount should be deposited by the due date of Form 940 or Form 940-EZ, which is January 31st. For a fourth quarter payment with liability of $500 or less, the employer can either make a deposit or pay the tax with the Form 940 or the Form 940-EZ by January 31st. The following table visually shows the dates when FUTA taxes should be deposited. Underpayment of employee taxes. If an employer withholds no income, Social Security, Medicare taxes, or less than the correct amount from an employee's wages, the amount can be made up later from the employee's wages. But the employer is the one who owes for the underpayment. Reimbursement should be settled between the employer and the employee. The withheld income tax must be recovered from the employee or on or before the last day of the calendar year. Part-time workers. There are no differences among full-time employees or part-time employees or employees hired for short periods for income tax withholding, Social Security, Medicare, and unemployment tax purposes. Advance Earned Income Credit, EIC. An employer is required to make Advance Earned Income Credit, EIC, payments to employees who complete and sign Form W-5. The employer must also notify employees who have no income tax withheld that they may be able to claim a tax refund because of the EIC. This requirement can be met by notification issuing IRS Form W-2 with the same statement, depositing taxes. In general, the employer must deposit income tax, and both employer and employee Social Security and Medicare taxes minus any advance EIC payments. By mailing or delivering a check, money order, or cash to a financial institution that is an authorized depository for federal taxes. The employer may make a payment with Form 941 instead of depositing if less than $2,500 tax liability is accumulated and the amount is paid in full with a timely filed return. When to deposit. There are two deposit schedules, monthly or semi-weekly, for determining when Social Security, Medicare, and withheld income taxes are to be deposited. The deposit schedule is not determined by how often employees are paid or deposits are made. These rules do not apply to the FUTA tax. Look back period. The deposit schedule for a calendar year is determined from the total taxes, not reduced by any advanced EIC payments, reported on the employer's Form 941 in a 4-quarter lookback. The lookback period begins July 1st and ends June 30th. If $50,000 in taxes or less was reported for the lookback period, then the employer is a monthly scheduled depositor. If more than $50,000 was reported, the employer is a semi-weekly scheduled depositor. New employers. During the first calendar year of business, the employer's tax liability for each quarter in the look-back period is 0. Therefore, this employer would be a monthly scheduled depositor for the first calendar year. Deposit period. The term deposit period refers to the period during which tax liabilities are accumulated for each required deposit due date. For monthly scheduled depositors, the deposit period is a calendar month. The deposit period for semi-weekly scheduled depositors are Wednesday through Friday and Saturday through Tuesday. Electronic deposits. Although some employers are required to make deposits using Electronic Federal Tax Payment System, EFTPS, all employers are allowed to use this system. The system enables users to transmit tax payments by phone or personal computer. For more information, call 800-555-4477 or go to EFTPS website at http://www.eftps.gov. Federal Tax Deposit, FTD. Coupon. Federal Tax Deposit Coupon. Employers who do not make EFTPS deposits need to use Form 8109, Federal Tax Deposit Coupon, to make the deposits at an authorized financial institution. The IRS will send fewer employers a Federal Tax Deposit, FTD, coupon book 5 to 6 weeks after they receive their employer identification number, EIN. The IRS will keep track of the number of FTD coupons used and will automatically send coupons when necessary. An employer who does not receive a resupply of coupons when needed can call 800-829-4923 to request them. Deposits without an EIN. If you're an employer who has applied for an EIN but has yet to receive it, you must not deposit at an authorized depository. You must follow these procedures instead to make a deposit. Make the deposit payable to the United States Treasury. Include your name as it appears on Form SS4. Include your address. Include the kind of tax the deposit covers, include the period for which the deposit is being made, and make note of the date when the application for the EIN was made. Do not make the deposit at an authorized depository. Send your deposit with an explanation to your local IRS office or the service center where you will file Form 941. Report and payment due dates. Report and payment due dates. The deadlines for filing various tax reports and the deposit requirements for FICA, FUTA, and federal withholding taxes can be seen in the following table, which summarizes due dates for A. Furnishing forms to employees, B. Filing forms, and C. Making deposits. This information can also be found in the IRS Publication 15, Circular E, Employer's Tax Guide, and Publication 509. For dates that fall on weekends, The due date is the next business day. If a deposit is to be made on a non-banking day, the deposit is considered timely if it is made by the close of the next banking day. The IRS has designated private delivery services as carriers for mailing tax returns and payments. These include Airborne Express, DHL Worldwide Express, Federal Express, and United Parcel Service. Figure 3.3, Summary Table of Due Dates. Here are the due dates, forms, and deposits. Penalties. Penalties may apply if you do not make required deposits on time, make deposits for less than the required amounts, or if you do not use EFTPS when required. Penalties do not apply if any failure to make a proper and timely deposit was due to reasonable cause and not willful act. Some of the specific reasons that the federal government will levy penalties and interest are the employer's failure to file tax returns, pay taxes by the due date, withhold or deposit monies, file information returns, furnish correct payee statements, or submit an accurate amount. Penalty amounts. Following are the penalty rates for amounts that were not properly or timely deposited. 1 to 5 days late, 2%. 6 to 15 days late, 5%. 16 or more days late, 10%. Deposits made in an unauthorized financial institution, 10%. Amounts subject to electronic deposit requirements, 10%. Amounts still unpaid more than 10 days after the date of the first notice the IRS sent asking for the tax due, or the day on which the employer receives notice and demand for immediate payment, whichever is earlier, 15%. Trust fund penalties. If income, Social Security, and Medicare taxes that must be withheld are not withheld or deposited or paid to the United States Treasury, the trust fund recovery penalty may apply. The penalty is the full amount of the unpaid trust fund tax. This represents a 100% penalty. The penalty may be imposed on all persons who are determined by the IRS to be responsible for collecting, accounting, and paying over these taxes, and who acted willfully in not doing so. The responsible person can be an officer or employee of a corporation, a partner or employee of a partnership, an accountant, a volunteer, director, trustee, an employee of a sole proprietorship, or an individual who signs checks for the business or has authority to spend business funds. Willfully means that the person voluntarily, consciously, and intentionally knew that the required actions were not taking place. Form 941 penalties. For each whole or part of a month that a return is not filed as required, there is a penalty of 5% of the unpaid tax due with that return. The maximum penalty is 25% of the tax due. Also, for each whole or part of the month the tax is paid late, disregarding extensions of the payment deadline. A payment of 0.5% per month of the amount of tax generally applies. This penalty is 0.25% per month if an installment agreement is in effect. The employer must have filed the return on or before the due date to qualify for the reduced penalty. The maximum for this penalty is also 25%. The use of a reporting agent of other third-party payroll service provider does not relieve an employer of the responsibility to ensure that tax returns are filed and all taxes paid or deposited correctly on time. An employer who goes out of business must file a final return for the last quarter in which wages were paid. Fair Labor Standards Act. The Fair Labor Standards Act, FLSA, establishes minimum wage, overtime pay, record-keeping, and child labor standards affecting the full-time and part-time workers in the private sector and in federal, state, and local governments. Exempt and non-exempt categories. The difference between exempt and non-exempt employees depends on who gets paid for overtime and who does not. Not knowing the difference between these categories could be costly. Employees who qualify as exempt are exempt from overtime regulations and minimum wage laws, whereas non-exempt employees must be paid for every hour of overtime they work. Many employers incorrectly believe that all salaried employees are exempt, or that by paying an employee a salary, they automatically become exempt. However, just as the labels employee and independent contractor don't determine a worker's actual status in the eyes of the IRS, the same is true for exempt and non-exempt employees in the eyes of federal and state labor departments. Exempt and non-exempt status has little to do with job titles and whether an employee is salaried or receives an hourly wage. Although in practice, hourly workers are never exempt, the legal definition of exempt and non-exempt has much more to do with an employee's level of responsibility or his or her status as a professional. The United States Department of Labor specifically designates certain classes of workers as exempt, including executives, administrative personnel, outside salespeople, highly skilled computer-related employees, and licensed professionals. In addition, managers who hire and fire employees and who spend less than half of their time performing the same duties as their employees are typically also exempt employees. The Federal Fair Labor Standards Act, FLSA, and the laws of the 50 states regulate what constitutes overtime. Handy reference guide to the Fair Labor Standards Act. The following section, which contains additional information about the Act, has been excerpted from the Handy Reference Guide to the Fair Labor Standards Act. This publication is available on the internet on the Wage and Hour Division homepage at the following address: https://www.dol.gov/WHD/. This material will be made available to sensory impaired individuals upon request. Phone number 1-866-487-9243. Handy reference guide to the Fair Labor Standards Act excerpts. Basic wage standards covered non-exempt workers are entitled to minimum wage of not less than $5.85 an hour effective July 24th, 2007. Remember, this is a 2009 document that I'm reading to you, and that anything contained herein or in any other video may be subject to change as the date or the book comes out. If one exists, I'm not reading from that one. $6.55 per hour effective July 24th, 2008. $7.25 per hour effective July 24th, 2009. Non-exempt workers must be paid overtime pay at a rate of not less than 1 1/2 times their regular rate of pay after 40 hours of work in a work week. Wages required by FLSA are due on the regular payday for the pay period. Covered deductions made from wages for such items as cash or merchandise shortages, employer-required uniforms, and tools of the trade are not legal to the extent that they reduce the wages of employees below the minimum rate required by the FLSA or reduce the amount of overtime pay due under FLSA. While FLSA does set basic minimum wage and overtime pay standards and regulates the employment of minors, there are a number of employment practices which FLSA does not regulate. For example, FLSA does not require vacation, holiday, severance, or sick pay, meal or rest periods, holidays off or vacations, premium pay for weekend or holiday work, pay raises or fringe benefits, or a discharge notice, reason for discharge, or immediate payment of final wages terminated employees. The FLSA does not provide wage payment or collection procedures for an employee's usual or promised wages or commissions in excess of those required by the FLSA. However, some states do not have laws under which such claims, sometimes including fringe benefits, may be filed. Also, FLSA does not limit the number of hours in a day or days in a week An employee may be required or scheduled to work, including overtime hours, if the employee is at least 16 years old. The above matters are for agreement between the employer and the employees or their authorized representatives. Exemptions. Some employees are exempt from the overtime pay provisions or both the minimum wage and overtime pay provisions. Because exemptions are generally narrowly defined under FLSA, an employer should carefully check the exact terms and conditions for each. Detailed information is available from local wage hour offices. Following examples are examples of exemptions which are illustrative but not all inclusive. These examples do not define the conditions for each exemption. Exemptions from both minimum wage and overtime pay. Executive, administrative, and professional employees, including teachers and academic personnel in elementary and secondary schools, outside sales employees, and employees in certain computer-related occupations as defined in the Department of Labor regulations. I'm going to read that one again because I missed it. Exemptions from both minimum wage and overtime pay. Executive, administrative, and professional employees, including teachers and academic administrative personnel in elementary and secondary schools, outside sales employees, and employees in certain computer-related occupations as defined in Department of Labor regulations. Partial exemptions from overtime pay. 1. Employees who lack a high school diploma and who have not attained the educational level of the 8th grade can be required to spend up to 10 hours in a work week engaged in remedial reading or training in other basic skills without receiving time and 1/2 overtime pay for these hours. However, the employees must receive their normal wages for hours spent in such training, and the training must not be job specific. Non-agricultural jobs, child labor. Regulations governing youth employment in non-farm jobs differ somewhat from those pertaining to agricultural employment. In non-farm work, the permissible jobs and hours of work by age are as follows. Youths 18 years or older may perform any job, whether hazardous or not, for unlimited hours. And youths 16 and 17 years old may perform any non-hazardous job for unlimited hours. Youths 14 and 15 years old may work outside school in various non-manufacturing, non-mining, non-hazardous jobs under the following conditions: no more than 3 hours on a school day, 18 hours in a school week, 8 hours on a non-school day, or 40 hours in a non-school week. Also, work may not begin before 7 a.m. nor end after 7 p.m. except from June 1st through Labor Day, when evening hours are extended to 9 p.m. Under a special provision, youths 14 and 15 years old enrolled in an approved work experience and career exploration program, WECEP, may be employed for up to 23 hours in school weeks and 3 hours on school days, including during school hours. Record keeping. The FLSA requires employers to keep records on wages, hours, and other items as specified in the Department of Labor record-keeping regulations. Most of the information is of kind generally maintained by employers in ordinary business practice and in compliance with other laws and regulations. The records do not have to be kept in any particular form and time clocks need not to be used. With respect to an employee subject to the minimum wage provisions or both the minimum wage and overtime pay provisions, the following records must be kept. Personal information, including employee's name, home address, occupation, sex, and birth date, if under 19 years of age. Hour and day when work week begins. Total hours worked each work day in each work week. Total daily or weekly straight time earnings. Regular hourly pay for any week when overtime is worked. Total overtime pay for the work week. Deductions from or additions to wages. Total wages paid each pay period and date of payment and pay period covered. Terms used in FLSA. Work week. A work week is a period of 168 hours during 7 consecutive 24-hour periods. It may begin on any day of the week and at any hour of the day established by the employer, generally for the purposes of minimum wage and overtime payment. Each work week stands alone. There can be no averaging of 2 or more work weeks. Employee coverage, compliance with wage payment requirements, and the application of the most exemptions are determined on a work week basis. Hours worked. Covered employees must be paid for all hours worked in a work week. In general, hours worked includes all time an employee must be on duty or on the employer's premises or at any other prescribed place of work from the beginning of the first principal activity of the workday to the end of the last principal work activity of the workday. Also included in any additional time the employee is allowed, i.e. suffered or permitted, to work. Computing overtime pay. Overtime must be paid at a rate of at least 1 1/2 times the employee's regular rate of pay for each hour worked in a worksheet in a work week, in excess of the maximum allowable in a given type of employment. Generally, the regular rate includes all payments made by the employer to or on behalf of the employee, except for certain statutory exclusions. The following examples are based on a maximum 40-hour work week applicable to most covered non-exempt employees. 1. Hourly rate. Regular pay rate for an employee paid by the hour. If more than 40 hours are worked, at least 1 1/2 times the regular rate for each hour over 40 is due. Example, an employee is paid $8 an hour for 44 hours in a work week. The employee is entitled to at least 1 1/2 times 8 or 12 for each hour over 40. Pay for the week would be $320 for the first 40 hours plus $48 for the 4 hours of overtime, a total of $368. 2. Piece rate. The regular rate of pay for an employee paid on a piecework basis is obtained by dividing the total weekly earnings by the total number of hours worked in that week. The employee is entitled to an additional 1/2 times this regular rate for each hour over 40, plus the full piecework earnings. Example, an employee paid on a piecework basis works 45 hours in a week and earns $405. The regular rate of pay for that week is $405 divided by 45, or $9 an hour. In addition to the straight time pay, the employee is also entitled to $4.50, half the regular rate, which for each hour over 40, an additional 22.5 for the 5 overtime hours, for a total of $427.50. Another way to compensate piece workers for overtime is, if agreed to before the work is performed, is to pay 1 1/2 times the piece rate for each piece produced during the overtime hours. The piece rate must be the actual paid during non-overtime hours and must be enough to yield at least the minimum wage per hour. 3. Salary. The regular rate for an employee paid salary for a regular or specified number of hours a week is obtained by dividing the salary by the number of hours for which the salary is intended to compensate. The employee is entitled to an additional 1/2 times this regular rate for each hour over 40 plus the salary. Example, if under the employment agreement a salary sufficient to meet the minimum wage requirement in every work week is paid as a straight time for whatever number of hours is worked in a work week, the regular rate is obtained by dividing the salary of the number of hours worked each week. To illustrate, suppose an employee's hours of work vary each week, and the agreement with the employer is that the employee will be paid $480 a week for whatever number of hours of work are required. Under this agreement, the regular rate will vary in overtime weeks. If the employee works 50 hours, the regular rate is $9.60, $480 divided by 50 hours, in addition to the salary, half the regular rate, or $4.80, due for each of the 10 overtime hours, for a total of $528 for the week. If the employee works 60 hours, the regular rate is $8, $480 divided by 60 hours. In that case, an additional $4 is due for each of the 20 overtime hours, for a total of $560 for the week. In no case may the regular rate be less than the minimum wage required by FLSA. If a salary is paid on other than a weekly basis, the weekly pay must be determined in order to compute the regular rate and the overtime rate. If the salary is for a half month, it must be multiplied by 24 and the product divided by 52 weeks to get the weekly equivalent. A monthly salary should be multiplied by 12 and the product divided by 52 weeks. It is a violation to fire or in any other manner discriminate against an employee for filing a complaint or for participating in a legal proceeding under FLSA. Willful violations may be prosecuted criminally and the violator fined up to $10,000. A second conviction may result in imprisonment. Violators of the youth employment provisions are subject to a civil money penalty of up to $11,000 for each employee who is the subject of a violation. Employers who willfully or repeatedly violate the minimum wage or overtime pay requirements subject to a civil money penalty of up to $1,100 for each such violation. Equal pay provisions. The equal pay provisions of the FLSA prohibit sex-based wage differentials between men and women employed in the same establishment who perform jobs that require equal skill, effort, and responsibility and which are performed under similar working conditions. These provisions, as well as other statutes prohibiting discrimination in employment, are enforced by the Equal Employment Opportunity Commission. More detailed information is available from its offices, which are listed in most telephone directories under United States government. Page 50. Child and youth labor laws. Federal child labor rules are established by the FLSA and affect full-time and part-time workers in the private sector and in federal, state, and local governments. The rules vary depending on the age of the youth worker and the type of occupation. The FLSA, the most sweeping federal law that restricts the employment and abuse of child workers, sets wages, hours worked, and safety requirements for minors, individuals under age 18 working in jobs covered by the statute. Child labor provisions under the FLSA are designed to protect the educational opportunities of youth and prohibit their employment in jobs that are detrimental to their health and safety. The Department of Labor is the sole federal agency that monitors child labor and enforces child labor laws. The Wage and Hour Division of the Department's Employment Standards Administration handles enforcement of the FLSA's child labor provisions. FLSA restricts the hours that youth under 16 years of age can work and lists hazardous occupations too dangerous for young workers to perform. The rules vary depending upon the particular age of the minor and the particular job involved. As a general rule, the FLSA sets 14 years of age as the minimum age for employment and limits the number of hours worked by minors under age 16. The FLSA prohibits minors under age 18 years old from working in any occupation that it deems to be hazardous. Among these occupations are excavation, manufacturing, explosives, mining, and operating many types of power-driven equipment. Certain industries allow minors under 18 to perform certain tasks at work sites where primary work activity is dangerous, but these tasks are very specific and the state and federal governments closely monitor them. The construction industry has many jobs and tasks that might border on the FLSA prohibitions. It is important that contractors remain aware of all jobs assigned to minors to remain in compliance with both federal and state laws. It is better to err on the side of caution and not assign questionable jobs to minors. The FLSA's minimum wage requirement do not apply to minors employed by their parents or by a person acting as their guardian. An exception would be in occupations deemed hazardous by the Secretary of Labor. The IRS has special guidelines concerning withholding for family members. Consult Circular E Employer's Tax Guide, IRS Publication 15. Every state has laws specifically dealing with child labor issues. When federal and state standards are different, the rules that provide the most protection to the youth workers will apply. Employers must comply with both federal law and applicable state laws. Special rules regarding employees under the age of 18 can be found at www.youthrules.dol.gov. Additional information concerning federal regulations can be found in fact sheet number 43, Youth Employment Provisions of the Fair Labor Standards Act, FLSA, for non-agricultural occupations. For additional information concerning child labor laws in the state, refer to Chapter 11, Labor Laws. Additional federal labor laws. In addition to FLSA, the Wage and Hour Division enforces and administers a number of other labor laws. Among these are Davis-Bacon and related acts, which require payment of prevailing wages and fringe benefits on federally financed or assisted construction. Walsh-Healy Public Contracts Act, which requires payment of minimum wage rates and overtime pay on contracts to provide goods to the federal government. The McNamara-O'Hara Service Contract Act, which sets wage rates and other labor standards for the employees of contractors furnishing services to federal government. Service Contract Act, which requires payment of prevailing wage rates and fringe benefits on the contract to provide services to the federal government. Wage garnishment law, which limits the amount of an individual's income that may be legally garnished and prohibits firing an employee whose pay is garnished for pay of a single debt. And Employee Polygraph Protection Act, which prohibits most private employers from using any type of lie detector test, either for pre-employment screening or job applicants, or for testing current employees during the course of employment. The Federal Employment Law Guide, publication OASP-01, is a guide that reviews the requirements of most other laws administered by the U.S. Labor Department. Contact can be made at https://web.gov.el.gov/ELAWS/EIG/Federal Unemployment Insurance. Unemployment insurance provides workers whose jobs have been terminated through no fault of their own monetary payments for a given period of time or until they find a new job. Each state administers separate unemployment insurance programs within guidelines established by federal law. Unemployment payments, compensation are intended to provide an unemployment worker time to find a new job similar to the one lost without financial distress. Without employment compensation, many workers would be forced to take jobs for which they were overqualified and end up on welfare. Unemployment compensation is also justified for sustaining consumer spending during periods of economic uncertainty. In the United States, unemployment insurance is based on a dual program of federal and state statutes. The Federal Social Security Act established the program in 1935. Much of the federal program is implemented through the Federal Unemployment Tax Act. Each state administers a separate unemployment insurance program, which must be approved by the Secretary of Labor based on federal standards. The state programs apply to areas normally regulated by laws of the United States, which employees are eligible for compensation. The amount they receive and the period of time benefits are paid as determined by a mix of federal and state laws. To support the unemployment compensation systems, a combination of federal and state taxes are levied upon employers. State employer contributions are normally based on the amount of wages they have paid, the amount they have contributed to the unemployment fund, and the amount their discharged employees have been compensated from the fund. Any state tax imposed on employers and certain credits on that tax may be credited against the federal tax. The proceeds from the unemployment taxes are deposited in an unemployment trust fund. The fund, each state has a separate account in the fund to which deposits are made. Within the fund, there are separate accounts for state administrative costs and extended unemployment compensation. During economic recessions, the federal government has provided emergency assistance to allow states to extend the time for which individuals can receive benefits. This is accomplished by passing a temporary law authorizing the transfer of money to a state from its extended unemployment account. The ability of a state to tap into this emergency system is usually dependent on the employment rate reaching a designated percentage within the state or the nation. For information about state unemployment coverage, refer to Chapter 11, Labor Laws. For information concerning regulations in Chapter 12, Tax Laws concerning payments. Americans with Disabilities Act, ADA. Title I of the Americans with Disabilities Act of 1990, which took effect July 26, 1992, prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms. Conditions and privileges of employment. An individual with a disability is a person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded in having such an impairment. An employer is required to make an accommodation to the known disability of a qualified applicant or employee if it would not impose an undue hardship on the operation of the employer's business. Undue hardship is defined as an action requiring significant difficulty or expense when considered in the light of factors such as an employer's size, financial resources, and the nature and structure of its operation. A qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job in question. Reasonable accommodation may include, but is not limited to, making existing facilities used by employees readily accessible to and usable by persons with disabilities, job restructuring, modifying work schedules, reassignment to a vacant position, and acquiring or modifying equipment or devices, adjusting or modifying examinations, training, materials, or policies, and providing qualified readers or interpreters. An employer is not required to lower quality or production standards to make an accommodation, nor is an employer obligated to provide personal use items such as glasses or hearing aids. Medical examinations and inquiries. Employers may not ask job applicants about the existence, nature, or severity of a disability. Applicants may be asked about their ability to perform specific job functions. A job offer may be based on the results of the medical examination, but only if the examination required for all entering employees in similar jobs. Medical examinations of employees must be job-related and consistent with the employer's business needs. Drug and alcohol abuse. Employees and applicants currently engaging in the illegal use of drugs are not covered by the ADA. When an employer acts on the basis of such use, tests for illegal drugs are not subject to the ADA's restrictions or ADA's restrictions on medical examinations. Employers may hold illegal drug users and alcoholics to the same performance standards as other employees. EEOC enforcement of the ADA. The United States Equal Employment Opportunity Commission, EEOC, issued regulations to enforce the provisions of Title I of the ADA on July 26, 1991. The provisions originally took effect on July 26, 1992, and covered employers with 25 or more employees. On July 26, 1994, the threshold dropped to include employers with 15 or more employees. On September 25, 2008, the President signed the Americans with Disability Act Amendments of 2008, ADA Amendments Act, or Act. The Act makes the important changes to the definition of the term disability by rejecting the holdings in several Supreme Court's decisions and portions of the EEOC's ADA regulations. Refer to http://www.eeoc.gov/ADA/amendments_notice.html. EEOC's representatives are available for assistance between 7 a.m. and 8 p.m. Eastern Time. An automated system with answers to frequently asked questions is available on a 24-hour basis. Phone number 1-800-669-4000. If you have a TTY device for hearing impaired, TTY number is 1-800-669-6820. This section provided a brief description of the ADA Act. For more complete information, consult the Department of Justice website, www.ada.gov/business.htm. Immigration Reform and Control Act, the IRCA. The Immigration Reform and Control Act of 1986, IRCA, was passed to control unauthorized immigration in the United States. The act designates penalties for employers who hire aliens not authorized to work in the United States. The employers must verify the eligibility of each employee hired after November 1986 to work in the United States by completing a USCIS, formerly known as INS, Form I-9. The employer must examine documents that establish the employee's identity and eligibility to work in the United States before completing this form. This examination should be done before the decision about hiring is made to avoid violation of IRCA's anti-discrimination provisions. Certain documents are acceptable on their own for establishing both identity and eligibility. These include the United States passport or permanent resident card. Other documents are not sufficient by themselves and require an additional supporting proof for establishing identity and eligibility. These include driver's license, social security card, voter registration, United States military card. Workers' compensation, federal regulations. Workers' compensation laws are designed to ensure that employees who are injured or disabled on the job are provided with fixed financial awards, eliminating the need to sue. These laws also provide benefits for dependents of those workers who are killed because of work-related accidents or illnesses. Some laws also protect employers and fellow workers by limiting the amount of an injured employee can recover from an employer and by eliminating the liability of co-workers in most accidents. Federal statutes are limited to federal employees or those workers employed in some significant form of interstate commerce. The Federal Employment Compensation Act provides workers' compensation for non-military federal employees. State workers' compensation statutes establish the framework for most employment coverage in the individual states. For additional information concerning workers' compensation coverage in the state, refer to Chapter 11, Labor Laws. Privacy in the workplace. Federal Privacy Act. The Privacy Act, passed by Congress in 1974, establishes certain controls over the type of personal information the federal government can collect and how it is used. The Act guarantees three primary rights: the right to see records about oneself, subject to the Privacy Act's exemptions, the right to amend that record if it is inaccurate, irrelevant, or untimely, or incomplete, and the right to sue the government for violations of the statute, which includes permitting others to see the company's record unless specifically permitted by the Act. Both the federal employee privacy regulations. Both the federal and state governments have provisions that protect the privacy rights of employees in the workplace. Personnel records generally state laws governing whether employees have the right to review their personal records related to employment decisions and search of employee property. The legality of a particular search of employees' property will initially depend on whether the employee's status is public or private. A public employer's ability to conduct searches is limited by the Fourth Amendment to the United States Constitution. Private employers are not constrained by the Fourth Amendment. Therefore, private employers are generally less restricted in their ability to conduct searches. The law generally states that the searches are allowed if an employer has a reasonable basis for suspecting the employee of wrongdoing and the search is confined to non-personal areas in the office. The office and company documents are relevant are considered the property of the employer and can be searched at any time. Telephone monitoring. Most states have passed laws that regulate telephone monitoring or recording of conversations. The Electronic Communications Privacy Act, ECPA, was passed by Congress in 1986 to regulate new forms of electronic communication. The ECPA protects most electronic communications, including email, from interception and unauthorized access. However, some courts have recognized an employer's right to review employee email. Although employees are prohibited from eavesdropping on telephone calls except in specific circumstances, employers are not specifically prohibited from reviewing an employee's email communications. Many state courts have considered common law claims based on evasion of privacy brought against employers that have either monitored or accessed their employees' email. However, there appear to be no cases to date that have found an employer liable for invading the employee's privacy by reading that employee's email. A sensibly crafted company email policy can help to avoid potential suits by notifying employees that email is not private and that by using the email system, they are consenting to have their use monitored. By informing employees that the email system is owned by an employer, provided for business purposes and may be monitored when necessary, and by explaining that the use of passwords and other security measures should not raise false expectations of privacy. Before deciding to monitor employee email, an employer would be wise to consult with an attorney. If you enjoyed or got benefit from Chapter 3, please watch Chapter 4.